On this lecture, we're going to use the 6 parts of the law of contracts. That is, we have organized it into these 6 parts. It is the law of contracts, but just organized into these 6 parts. Part 1, formation. Part 2, clarifying the terms. That's parole evidence, rule, ambiguity, mistake. Part 3, changes in the contract. Part 4, was there breach of contract? Part 5, the remedies that you can get for breach. And Part 6 is quasi-contract. And again, Part 6 is when you don't have a contract, or you had one, but it came to an end before the contract was completed. What we're going to do with these is I'm going to use the questions that I told you you needed to pre-read: Motors versus Jones, the buyer-seller turbine, and Owens-Carter question. I'm also going to use one other question to show you how, when you look at a question for the first time under bar exam conditions, you can begin to organize your answer in terms of these 6 parts, and there are rules of law within these 6 parts that you would then use. Let's begin with the first of these questions, and that is the Motors versus Jones question. Now, you need the actual question in front of you, because I'm going to talk to you about the specific word-by-word parts of this question. So if you haven't downloaded it or printed it or whatever you need to do to get it in front of you, please stop the video and do that, because I'm going to go word by word. Looking at the Motors versus Jones question in the first paragraph. The first paragraph tells us that on January the 15th, 1983, Jones agreed with Motors in writing, signed by both, to supply Motors with 10,000 pounds of specifically described bolts each month for a period of 10 months, beginning March the 1st, and the stated price of 85 cents a pound. And stopping right there, at that point, the bar examiners have told you everything they're going to tell you about formation of a contract. And the question at this point is, do these people have a contract? You go through the analysis and you will be able to quickly establish that indeed they have a contract. Now notice the bar examiners did not say to you that Motors and Jones had a contract, because if they said they had a contract, you should stop. According to the facts, they've got a contract, and proceed. But they didn't say that. The facts of this question says that on January 15th, Jones agreed with Motors in writing. It doesn't say they had a contract. So you have to establish that that agreement that they had amounted to a contract. So you go through the formation rules and you find they have a contract here. We'll go through them later. Continuing with the same problem, starting after 85 cents per pound, it says next, on February the 1st, same year, Jones, in good faith, notified Motors he could not afford to sell the bolts at the agreed price. He said he would charge 90 cents per pound, and Motors orally agreed to the increase in price to begin with the first installment. Now obviously these people are trying to modify the contract. And so if we look over here, they formed the contract here. There were no issues regarding clarifying the terms. There was no parole evidence rule issues, no ambiguity, no mistakes. You'd say nothing about that. Changes in the contract, these people are obviously seeking to modify the contract because they want to change the price from 85 to 90 cents a pound. So we're at modification. The question is going to be, what does it take to modify a contract? Since we're talking about it briefly, let's summarize that quickly. To modify a contract requires 3 things. The parties must agree on the new terms. In some cases, you need consideration. Under the old common law, you needed consideration. Modernly, under the UCC, all you need is good faith. You do not need consideration. This was the old pre-existing duty rule that you have learned about in school. But under the UCC, all you need is good faith. You don't have to deal with the pre-existing duty rule. So the 3 things to modify a contract are: the parties must agree on the new terms. You do not need consideration under the UCC, You do it at common law, you may or may not. And and finally, no effective defenses. And these defenses to modification are exactly the same as the defenses to formation of a contract. Now, obviously, at this point, we have not discussed the defenses yet, but we will. And the defenses are the usual ones. They are statute of frauds, fraud, duress, etc. They're in your materials. Now, so these people, beginning when it says on February the 1st, Jones, in good faith, notified Motors that he could not afford to sell the bolts at the agreed price and he would charge 90 cents instead of 85 cents. Obviously, Jones is proposing a modification to the contract, new terms, and they agreed on the new terms because they agreed that the new price would be 90 cents. So they agreed on the new terms. This is a UCC problem. You don't need consideration. You should mention early in the analysis that this is a UCC problem and why. And the defenses, well, this modification was oral. And the question becomes, does this modification need to be in writing? Because if it does need to be in writing, then we do not have an effective modification yet because it's still oral. So continuing then, still dealing, they said that they agreed on the price, the new price. You don't need consideration for a modification in good faith under the UCC. And now going to the next paragraph, we're now about to deal with this statute of frauds problem, the one right here. And in the next paragraph, let me tell you about how we're going to deal with it, and you see it in the next paragraph. The UCC 2-201 deals with the statute of frauds, and it says that in the case of a UCC sale of goods, if the price of the goods is $500 or more, then the contract to sell these goods needs to be in writing, and it needs to be signed by the party who denies the contract. We often talk about the party to be charged, and that's a little confusing. So you need a writing if you're going to have a contract for the sale of goods for $500 or more. Now the question becomes, suppose you have a modification and you have a contract and then the contract gets modified. Does that modification need to be in writing? And the answer is really more a continuation of the first rule. That is to say, if you're going to have a contract for the sale of goods for the price of $500 or more, it needs to be in writing. And it doesn't matter how you got there. You could start with a contract for $300 and you modify it and change it and you end up with a contract for the sale of goods for the price of $500 or more. You need a sufficient writing to prove that you have this contract. Doesn't matter whether you got there through a bunch of modifications or you got there the first time without any modifications. If you end up with a contract for the sale of goods for the price of $500, you got to be able to prove that with a writing. And the writing has to have the enough to show intent to contract and the quantity term under the UCC. Under the common law, you need the essential terms in writing. UCC, you just need the quantity. The writing needs to show intent to contract. It needs to show the quantity term, and that's all you need for the UCC. You don't have to have the price. Common law, you needed the price. Now, in our case, the place where we ended up after all this modification has taken place is the place we've ended up is with a contract for the sale of goods, the sale of these bolts for $90,000 worth of bolts. So obviously it needs to be in writing. Well, if the modification is in writing, that the original contract was written 85 cents. Now if the modification shows the new price is 90 cents, then everything you got a writing with everything you need. even if you didn't have a contract initially in writing and you made the modification and you put the modification in writing and the writing contained everything you need, that's enough of a writing to prove the final contract that you ended up with. So what you need is if you end up with a contract for the sale of goods for the price of $500 or more, okay, you need a writing to prove it, and it doesn't matter how you ended up getting there. It's the fact that that's where you ended up, you need the writing. So if I'm going to sell you my car for $300 and we modify, and we don't have a writing, and I modify the contract because I'm going to put new tires on it, and now I'm going to sell it to you for $500, that modification needs to be in writing. Or something needs to be in writing. You could just rewrite the whole, whatever you want to do. You need a writing now. You didn't need it before. If I have a contract to sell you my car for $700, and we agree because I've dented the fender, I'm now going to sell it to you for $499.99, okay? Well, the place where we ended up is a contract for the sale of goods for the price of less than $500. So we do not need a writing. Doesn't matter how you got there. Now, so we understand how that works, but in this case, we are dealing with a special section of 2-201, subsection 2. And 2-1, subsection 2 says that if you have a merchant, if you have a contract between two merchants. Now, between two merchants means both parties have to be merchants. That's the only way to be between two merchants. If one's a merchant, the other one's not, it's not between two merchants. But if you have a contract between two merchants, you can satisfy the statute of frauds in a way that you can't do if only one of the parties is merchant. In the case where two parties are merchants, you're a merchant, I'm a merchant, that means, now by the way, when this comes up, every time this has come up on the bar, there's been an issue as to whether or not these two people really are merchants, okay? And so you need to know the rule, 2-104, that deals with whether or not someone really is a merchant or not. But assuming these two people are both merchants, and we'll prove that later, that they're both merchants, then if you and I are both merchants, and we have an oral contract for the sale of bolts or tires or something, and we're both merchants, and if I send you a written confirmation signed by me, and the written confirmation is enough to bind me, mind you now, these are all requirements of this special rule at 2-201 subsection 2. I send you a written confirmation, and you get it within a reasonable time. This is all subsection 2. And what I sent you is enough so that I am bound. It's signed by me. It's got enough details in there so that I am bound. You get it within a reasonable time. Next factor, next requirement, you have reason to know of the contents of the message I sent to you. I sent you a letter, and it's from me. You don't get letters from me every day. That's probably enough. And we just negotiated a contract yesterday. That's probably enough for you to have reason to know what's probably in there. Certainly if I told you I'll send you a written confirmation right away, then you surely have enough evidence, you have reason to know what's in there. So you have to have reason to know what's in there. You don't have to read it. You have to get it within a reasonable time. It's enough to bind me. Reason to know of the contents. And then you don't object within 10 days of the date that you got it. You can send me an objection. And if you don't object in writing within 10 days of when you got it, then you, a merchant, who didn't sign anything, you are just as bound as if you had signed it. Okay? This is a special rule that only works between merchants. Now let's look at what we have in this problem. And we're dealing with satisfying the statute of frauds right here for the modification. We didn't need to satisfy the statute of frauds we didn't need to do anything for the basic problem because they already told us that one was in writing. But this rule could work for a modification or the original contract. Either case, between merchants, you can satisfy the statute of frauds by this special process. Let's see what we have here in the second paragraph. A written confirmation. Aha. Now, assume we've already proven that Motors and Jones are merchants. We have not, but you'd use 2-104 to do that. It says, in a written confirmation signed only by Jones. Okay? and delivered to Motors. So Motors actually got it. Delivered to Jones's secretary. It mistakenly typed the price of 91 cents per pound. Well, 2-201, if you read it carefully, says even if you make a mistake in the writing, you typed something that wasn't quite what you meant, that writing can still satisfy the statute of frauds even though it contains a mistake. This writing contains a mistake, 91 instead of 90. It can still satisfy the statute of frauds. Okay? But 201 goes on to say that if the mistake is as to quantity, the contract is not enforceable beyond the quantity actually recited there. So we have a mistake, but that's okay because 2-201 says mistakes in the writing are okay. And then it says Motors received the confirmation. So he actually received it, but did not read it and did not reply to it. Okay, he had reason to know of the contents because they just formed a contract. The only problem now is it says that the code says that Motors must receive this within a reasonable time. They have to receive the writing, the written confirmation. When did Motors receive it? And if you look at the facts here, it says Motors received it, but it doesn't say when. So you need to raise that issue that as to when Motors received it is still open to question. But looking at what happened after that, it looks like Motors must have received it within a reasonable time. So what we have then is that 2-201 subsection 2 can be used to satisfy the statute of frauds as to both Jones and Jones signed the written modification, so it's not a problem. It's Motors. Motors got it, and all those requirements are satisfied. So it's just as though Motors signed it, even though Motors did not sign anything. So where we are in our general structure here then is that in this problem, you can see that when you get down to where it says in the first paragraph, they stated the price at 85 cents per pound, that they had formed a contract at this point. It's in writing and everything is all there. Now we haven't proven it here, but you see that it's all there. They formed a contract. There were no issues regarding clarifying the terms, so you say nothing about that. As to changing the terms, they tried to modify the contract. To modify the contract, they needed to agree on the new price. They did that. They do not need consideration. UCC 2-209 subsection 1. 2-209 subsection 1 says for a UCC contract, you do not need consideration for a modification. You need good faith, but you don't need consideration. And for the modification, you need to agree on the new terms, no consideration, no effective defenses. Statute of frauds would apply because they're selling $90,000 worth of bolts, but the modification is in writing and by using 2-209 subsection 2, so they've satisfied the statute of frauds. So we have a good modification. Now what I want you to see is that by the time you have finished the first two paragraphs, you have completed the formation and a modification. You form the contract, and the parties tried to modify it over here, and they've modified it successfully because all three of these requirements have been satisfied. Okay. Now, continuing with this same problem, in the very next paragraph it says, prior to March 1st, Jones notified Motors that he would deliver no bolts because he had just contracted to sell his entire output to Ted for $110 per pound. Now, so this is obviously a breach. So we've gone through, we've got a modification. After the modification comes the breach here, part 4 of our breakdown. And so do we have a breach? The answer is sure we have a breach by anticipatory repudiation. I'm not going to go through all the details of breach right now, but obviously you tell somebody you're not going to perform, and that's a breach by anticipatory repudiation. So we've got a breach. So far we have a formation, we have a modification, we have a breach. Now, the rest of this problem is about the damages. we'll go through that shortly, but the beginning at the next paragraph in the same problem, it says, despite diligent efforts, Motors was unable to buy bolts from anybody else until May 1st. Well, that's his duty to mitigate. Now that he's been informed that there's a breach, you have to attempt to mitigate damages. So he's attempting to mitigate damages. That's one of the requirements to collect your damages. And then the next two paragraphs deal with how much damages the person, Motors, is entitled to. And it deals with, in particular, the Hadley versus Baxendale rule that says you can only collect the damages which were foreseeable when the contract was formed. And they tell you in these next two paragraphs that Jones didn't know about some damages that Motors was going to suffer. And since Jones didn't know about the damages that Motors would suffer if there was a breach, then Motors will not be able to collect those damages from Jones, because you can only collect the damages foreseeable when the contract was formed. And that's the damages part, and they gave you some stuff to do on damages. So you see how this problem is organized. Formation, modification, breach, damages. Okay? And obviously you should write it in some structure that kind of takes care of that. Let's look at another problem, and we're looking at structure, not detail so much at the moment. In the problem we're next going to look at is the buyer-seller turbine problem. Now, in the buyer-seller turbine problem, in the first paragraph says that buyer is a builder of industrial plants and requested that seller, one of his regular buyers, to submit a proposal for supplying a turbine. So this person is asking for an offer, and it says several days later that seller phoned buyer, this is all by phone, and offered to produce and install the turbine according to the specs. Now, obviously, you're still in the formation stage. Buyer had supplied, he offered to do it according to the specs at a price to be agreed upon later. Can you form a contract when the price is to be agreed later? Under the UCC, yes, 2-305 lets you do that. So these people, this person says, I'll do it with a price to be agreed upon later. Is that a good offer? Sure it is. Then the buyer says, I accept this offer so long as the price doesn't exceed $400,000. Well, that's an attempt to accept, but it's obviously a conditional acceptance, so you don't really have an acceptance yet. And it says, during this telephone conversation, he accepted so long as you don't exceed $400,000. And he emphasized delivery by February the 15th was essential. That's a question of his time of the essence here. And then, so seller then assented to buyer's response. So now they have a contract. You saw all this dickering back and forth. So by the time you have finished the first paragraph, these people have formed a contract. So we're right here, finished the first paragraph, they formed a contract. Obviously, you've got a lot of details to work with there, but I want you to see the structure before you work with the details, because if you get the structure right, you'll have a much cleaner organization of the answer than if you're sort of wandering from issue to issue. So in paragraph 1, we have completed the formation of a contract. Second paragraph, the next day, buyer sent a written confirmation. Now you got a problem, because formation of this contract is going to require satisfying the statute of frauds. Again, we have not filled out the details for forming a contract, but you know that in fact, I'll put the structure on the board right now. The formation of a contract requires 3 things. Let's put that on the board now. Formation of a contract requires agreement on the essential terms, you have to agree on the essential terms. Consideration must be part of a bargain, and no effective defenses. 3 things to form a contract. Those 3 things are: the parties must agree on the essential terms. What are the essential terms? The essential terms of any contract are, what am I going to do for you? What are you going to do for me, and when are we going to do it? Those are the essential terms. The parties have to agree on that. Consideration means that this whole deal has to be part of an exchange, part of a bargain. I'll do something for you if you'll do something for me. If I'm just doing something for you, that's a gift. It has nothing to do with the law of contracts. I'm just going to make a gift to you. But if we're making a bargain, I'll do for you if you'll do for me, then the law of contracts does apply. So you need, that's called consideration. So you need a bargain and no effective defenses. What are the defenses? Well, in your materials you will see that the defenses to forming a contract are statute of frauds, fraud, duress, unconscionability, lack of capacity, and mistake. So in our problem with the turbine, the parties agreed on the essential terms. You have to work out the details because there was a lot of back and forth offering and counter offering and stuff. But ultimately they agreed on the essential terms. This is obviously part of a bargain, trading of the turbine for money. And when they formed the contract for the turbine, it was all on the phone. So the statute of frauds has not been satisfied. And how are you going to satisfy the statute of frauds? Well, you don't have an enforceable contract until you do, and it is in the next paragraph that they start to satisfy the statute of frauds here. So in the next paragraph it says, the next day buyer sent a written confirmation. Well, we know about that. We've seen those before. Written confirmation, and we know that if these people are both merchants, and again, you're going to have to prove that they're both merchants. 2-104 tells you how to do that. You have to prove they're both merchants. If they are both merchants, then one merchant can send a written confirmation to the other one and bind the other one, provided that what you send, that they actually get it, that they get it within a reasonable time, that they have reason to know what's in the contents of what you sent them, that if they don't object within 10 days in writing of the time that you got it, then this receiving merchant is just as bound as though they signed. We went through that in the previous problem. So in this case, they're trying to satisfy the statute of frauds in exactly the same way. So you look to see, did they do it? And the second paragraph says, the next day buyer and seller sent seller a written confirmation that referred to the specifications that buyer had given seller. That's fine. You need, remember that what is sent to the other merchant has to be enough to bind the sending merchant. And if you don't say what the contract is about, the sending merchant won't be bound. So here they told you what all was in there, and so what was there was enough. And then at the end of that paragraph it says, and there's other stuff in there, by the way, some 2-207 stuff, but we're not talking about that stuff now. We're talking about just forming the contract, not whether or not some proposed additions are included or not. We'll come to that. So all that stuff in the second paragraph has to do with 2-207, whether or not these proposed additions will end up in the contract or not. But at the end of this second paragraph it says, shortly after receiving the confirmation, seller went to work. So we know seller got it, okay, and it probably had reasons to know what was there. It was and so forth. And so we have probably satisfied all the requirements of 2-201 subsection 2. So at this point, buyer and seller have a contract regarding the turbine. There is still a question as whether or not in that second paragraph there's a $1,000 liquidated damages clause, and there's an agreement that all changes must be in writing, and there's an agreement that the usual warranties apply. These were all additions to the contract that were included in that confirmation that buyer sent to seller. And whether or not those additional provisions will end up in the ultimate contract or not is a question of 2-207. We will deal with that. But right now we're just trying to form the contract. We have formed it. The parties agreed on the turbine. They agreed the price doesn't have to be set now. It was that we do have consideration. The statute of frauds has been satisfied, so we don't have no effective, there aren't any other defenses, there's no fraud, there's no duress, no unconscionability, no lack of capacity. The person is not a child, for example, they don't lack capacity, no mistake. So you have formed a contract. Now, beginning in the third paragraph of this same problem, it says, on January the 15th, buyer called, remember this, the performance of the turbine is due on February 15th. It says on January 15th, buyer received a letter from seller requesting a 1-month delay. Well, that's a modification. Okay? So these people now, we don't have any problem in this problem regarding clarifying the terms. We formed a contract. We do not have to clarify terms. They're trying to make a modification. The modification, what do you need? Just like before, you need to agree on the essential terms. The modification. You don't need consideration for a modification under the UCC and look for defenses. Well, on this modification, did they agree on the 1-month delay? Well, the facts say buyer phoned seller. Notice it's not in writing. What seller sent, by the way, is in writing, because seller sent a letter saying, can I have a month? Well, when seller sent that letter to buyer saying, can I have an extra month, that letter signed by the seller is probably enough to satisfy the statute of frauds anyway. But in any event, so we have two ways to satisfy the statute of frauds in this problem so far. Number one, the 2-201 subsection 2 by way of the written confirmation that buyer sent to seller, that seller received, and so forth. That's one way to satisfy the statute of frauds against the buyer. And the other way is that the buyer, against the seller. And the other way is that the seller sent this letter saying, can I have more time? Well, that letter probably identifies the contract enough that you got enough of a writing to show that these people had a contract. So that's the second way of satisfying the statute of frauds. And continuing in this third paragraph, says buyer phoned seller, and after hearing seller's reasons for the request for additional time, he said that the 1-month delay would be okay. Okay. So now notice that buyer hasn't signed anything. The original contract, but in this modification, buyer didn't sign it. So you have a contract that is where the date for delivery has been changed by 30 days, but buyer, who is hasn't signed that, and there's no written confirmation or anything. So buyer never signed that modification, and you don't have anything to show that the modification is effective against buyer. Now, the one thing that you do have is that buyer, if you can prove that buyer orally agreed to this modification, is that buyer may have waived the time for completion being February 1st, have waived that so that you now have more time. So you can waive things when you agree to a modification that should have been in writing, but it's not. That agreement can be treated as a waiver of whatever and if the other side has relied. If the other side has relied, then you can treat it as a waiver. If the other side hasn't relied, then you just don't have anything at all. Now here's a case where a buyer says, okay, seller, you can have the other 30 days. And now seller is relying. And so that this could be treated as a waiver, that buyer has waived his rights to have the thing finished on February 15th, and now has moved the date to March 15th because seller has relied on this promise that we can have an extra 30 days. But structure right now, more than detail, these people formed a contract over here. They satisfied the statute of frauds in the formation. These people modified the contract here. They did not satisfy the statute of frauds as to the modification, but it might be treated as a waiver if the seller has relied on this oral statement. Now, continuing with our problem, it says that the next paragraph, on February the 20th, now this is 5 days after the turbine was originally due, and if this modification is not valid so that the seller has an extra 30 days, if that modification is not valid, okay, then the seller is already 5 days late. If the modification is valid, then the seller's got till March 15th to finish. But if the modification is not valid, then they're already 5 days late. So you see how this turns on whether or not the modification is valid. Then it goes on to say that on February the 20th, buyer learned from a reliable source that seller had already finished the turbine, was about to sell it to a third party to make some extra money. And when buyer finds out that this is what seller is doing, buyer now realizes for the first time that when seller called and said, I want an extra 30 days, that seller really wanted that extra 30 days so they could sell buyer's turbine to this third party named Ted. So they could sell that and make $30,000 extra money. So when buyer discovers that seller has in fact completed the turbine and is about to sell it to somebody else, then at that point, buyer realizes that he's been defrauded. And he was defrauded in the telephone call. And since the telephone call, since the reasons that the seller gave to buyer for the 30-day extension almost surely was not, oh, I'd like to sell your turbine to somebody else to make some more money. They lied to him about it, almost for sure. And so since seller has lied to the buyer, then the extension, the 30-day extension, was obtained by fraud. And if you obtain an extension by fraud, obviously that's a defense to the modification right here. Right here. They haven't satisfied the statute of frauds as to the modification. They did not satisfy the statute of frauds as to the modification, but we may get by that because the seller relied on the extra 30 days and they'll be treated as a waiver. But seller also committed fraud when he lied on the telephone about why he wanted the extra time. So the entire modification is void. So since the modification is void, then the performance is now 15 days late, and buyer can get buyer's entitled. There's a breach. It's 15 days late. The remedies for breach are money damages and are remedy. Now take a look at this here in this case. What the bar examiners ask you, they say, what are buyer's rights? How much money is buyer entitled to? And it says, and to what relief and remedies? Here, equity. So they're asking you about both. As to buyer's rights, well, in this case, they've got a liquidated damages clause that they tried to add to the contract under 207. We haven't decided, we haven't dealt with that yet. But if the liquidated damages clause of $1,000 a day is still valid, if it's valid, then you need, if it's valid, then they're 5 days late and the seller owes buyer $5,000. Plus, the buyer can still try to get specific performance. And you go through the elements of specific performance. Inadequate remedy at law, buyer will say, my remedy at law is I'm building this and it's going to mess up my schedule. It's hard to figure out what damages would be. I want the turbine. Definite contract terms, that's clear. Feasible to enforce. It's feasible to enforce this because the court can just say to the seller, deliver the turbine to buyer. Mutuality, sure, if they deliver the turbine, buyer's going to have to pay for it. Defenses, the buyer does not have unclean hands or anything of that sort. So the buyer should be able to get specific performance, and the key issue here regarding specific performance is whether or not the remedy at law is inadequate. The rest of these are giveaways. Definite terms, there's nothing ambiguous about any of the terms. Feasible to enforce, sure, the court can say to seller still has the turbine, give it to buyer. Make buyer pay for it. There are no defenses. There's nothing, you have to fill these in. But the real problem here where you'll get substantially more points is if you dig in here at whether or not the remedy at law is inadequate, because buyer is building a plant for Carlson, and he's got a schedule to finish, obviously, and you've got to make some arguments here that getting that late, that usually when people are building stuff, getting things late, is a big deal and messes up their schedules, etc. May have to lay people off work, and he told them February 15th was essential, the very critical date. And so give them some serious argument about whether or not the money remedy at law is inadequate. You still give buyer the $5,000, but you'll get substantially more points if you make your argument here. So you see, once again, the structure of this contracts problem. The structure is the parties form the problem. There's some back and forth on the formation. There's a statute of frauds issue regarding the formation. There are no issues regarding clarifying the terms. There is no parole evidence rule, ambiguity, or mistake. They did attempt to make changes. They tried to modify the contract. They tried to modify the two big issues here, and the modification was, again, you have to cover them all, but was the statute of frauds and actual fraud itself. And then there was a breach, and clearly there was a breach because the person, the modification is void, so the goods were due on the 15th of February. There's a breach, establish the breach. The remedies is a legal remedy, $5,000, equitable remedy, specific performance. And that's the structure. And if you wrote the question, the answer to the question, with that kind of structure and did a decent job on the detail, you get a great answer, great grade. But you see that seeing the structure is a big deal. Now, I have one more problem where I want you to see the structure. This problem is not among the first three that I said that you needed. I originally, at the beginning of the lecture, pointed out that you need these three problems, okay? And I'm going to do a fourth problem that you have among your materials. Please get it out because I want you to see it. The reason I'm going to do the fourth problem is that the fourth problem I'm going to do is also a UCC problem. The first two, Modas versus Jones and buyer-seller turbine, were both UCC problems. The Owens versus Carter is a common law problem. I'll do that in just a minute to show the structure, but I want to do one more UCC problem so you can see the structure. And this problem is the Stan, Barb, Tom problem. It's in your materials. And this is a UCC problem. Please pull it out of your materials because we're going to go through it word by word, and you need the problem in front of you. In this Stan, Barb, Tom problem, the first paragraph says, Stan and Barb entered into a valid written contract. You know, this is not UCC. It's also common law. It's a sale of real estate. So we have two common law problems. I'll do them for you. So we're doing this problem now, Stan, Barb, Tom. And in that problem it says, Stan and Barb entered into a valid written contract. Now there go your formation issues. Everyone agrees, I think you don't have any formation issues because they told you they had a valid contract. That's all you say about it. According to the facts, they had a contract. You may want to lay out what the terms were, what Stan was supposed to do for Barb and what Barb is supposed to do for Stan and when they're supposed to do it. But don't go through some offer acceptance kind of analysis. They had a contract whereby Stan agreed to convey to Barb 100 acres of agricultural land and water rights in the adjacent stream. And Barb agreed to pay Stan $100,000. So you know what each party is supposed to do for the other one. When Stan and Barb were negotiating the deal, Stan said, quote, you know I want to make sure the property will be used for farming and not developed, close quote. Barb replied simply, well, this is quotes, well, I can certainly understand your feelings, close quote. In fact, Barb intended to develop the land as a resort. And so these people are in the process of trying to form a contract, and you see that there's something wrong here. And the question really is, they told you they formed a contract, and they've agreed on the essential terms. This is a bargain. The real problem is with the statute with fraud, not statute of frauds, but fraud itself. Because in this problem, isn't it true that Stan is being deceived? So Stan is being deceived, and there's a question of whether or not it amounts to fraud. And you have to know the rules and drag them out and put them to use here. But this is all part of formation. So we have forming a contract in which Stan might be the victim of fraud, so they might not have a contract at all, and they might, depending on whether you find fraud or not. Continuing with the problem, it says in the second paragraph, the conveyance was to take place on June the 1st. On May 15th, Stan called Barb and told her that the deal was off. Stan said that a third party, Tom, was going to pay him $130,000. And Stan also said he had discovered that Barb intended to develop the land. Aha. So what you have at this point, contract's been formed, probably fraud. They did not have any problems with parole evidence rule, ambiguity, or mistake. They did not attempt to change the contract in any way. There's no attempted modification or waiver. They didn't assign, there are no third-party rights involved. So far we've formed the problem, formed the contract, we formed it, nothing about clarifying terms, nothing about changing terms. Now comes the breach. Tom calls Barb and says, I'm not going to do it. Well, that looks like a breach by anticipatory repudiation. We haven't dealt with all the breach, we're dealing with structure now. Looks like a breach by anticipatory repudiation, but you have a breach only if they really had a contract. Because of the fraud, maybe they never had a contract, it wasn't enforceable. And so Barb may or may not have some rights here. She may not have any rights because of the fraud, and she may have a right to enforce the contract if you don't find fraud. So that's where you are. And he knows now that she misrepresented her intents about developing, and so the question is, do you have the fraud? Continuing. So far we have formation and a possible breach. Continuing. On May the 16th, now notice that this is one day after Tom was supposed to deliver. On May 16th, Barb discovered that Stan's title only had title to 90 acres and did not have the water rights. Well, I don't know if they have a contract at all, but if they have a contract, and they may or may not, if they do have a contract, and if Tom conveys to Betty what he's got, that's going to be a breach. It's going to be a breach of contract. If there's fraud, there's no breach. If there was fraud and he conveys not 10 acres less of land and no water rights, that's a breach. And what remedies is she entitled to for the breach? Well, she's entitled to her legal and equitable remedies. Her legal remedy is the money damages difference between the 90 acres and 100 acres. You've got some numbers there and you figure out what that is worth. And secondly, Tom won't convey it and she wants specific performance. So you have to go and do your specific performance analysis to get the remedy. And one of the things, remedy at law is inadequate because it's land. It's always inadequate for land. The terms are definite, feasible to enforce. Mutuality is not a problem. Defenses. Isn't this, what's her name, Barb? Doesn't she have unclean hands? Wasn't she trying to defraud him to begin with? Of course she was. And so you have issues there with the key issue there is not the inadequate remedy at law because it's land, and all land is considered unique. So the remedy at law is automatically that, but her defense of unclean hands is where you'll get the extra points. So you see the structure, okay? And these problems are laid out with that kind of structure. Now, we next have one more problem we want to look at. That is, we want to look at the problem of Owens and Carter. And again, we're looking at it from a structural point of view. I'll come back to these problems shortly and go through the analysis of more detail. Looking at the problem of Owen versus Carter, which you need to have in front of you, it says that Owen is a homeowner and approached Carter about who is a licensed contractor, about building a garage for him. And it says, after several meetings, Owen and Carter signed the following contract. And they told you what the terms of the contract are here. And that he was to build a garage, and they told you what size the garage was and all that. Now, these people obviously have a valid contract. You run through some quick, they agreed on the terms. To form a contract, they have to do the usual stuff. They have to agree on the essential terms. They did. A bargain it was. No effective defenses. Well, this is common law, not UCC. So, and you go through these defenses, none of them work. And so these people have a good contract. It should take you one paragraph to explain why they have a valid contract. Then in the next paragraph it says the contract was signed on the 15th of January and Carter arrived. By the way, they could have done the entire thing orally. Okay, they didn't need a writing because this is not sale of goods, this is services. They could have done it all without the writing, but they have a writing anyway. Carter arrived on the job on March 15th to begin work. Now, according to the facts, he's supposed to finish no later than April the 30th. Well, March 15th to April the 30th is 6 weeks, and that apparently is enough time to build a garage. Continuing, it says, several weeks later, Carter learned that roofing shingles of the exact type and color used on Owen's home would be difficult to obtain. Now, one of the parts I did not read to you is that it says that the shingles are to be matched with the wooden siding of the house. So the wooden siding and paint and roof will be matched to the house. And so what the builder is saying is, I can't match the shingles exactly, the exact type and color that we use. It says, but I'm going to use some shingles made of other materials which were even higher quality than those planned. Although they're very close, they did not match precisely those that were already on the roof. The shingles are on the roof, doesn't match precisely the new shingles for the garage. You can see how if you're building a garage, you would want the shingles on your garage to look like the shingles on your house. And here the builder did not match them perfectly, and so that's what happened. So he is performing the contract. Now notice, in this case, we had no problems with forming the contract. We had, but now they're in the course of performing the contract, and this problem comes up that he can't find, or it's hard to find the right shingles. Carter completed the garage. By the way, what's going to happen, just to clarify this before we put any more facts on the table, he couldn't find the right shingles, so he used shingles on the garage that were close but not an exact match. And the obvious problem is going to be, is that a breach? And so when we come to the breach, the question is going to be, how closely do the shingles have to match when the contract said matched? And the answer to that is going to be that when you use the term matched in an industrial contract like this, then the industry's use of the term matched is what will be used. Okay, whatever industry can, like if I'm having my fender on my car repaired because I dented it, obviously I want the fender that's being repaired and repainted to match the fender match the color of the rest of the car. You know how perfectly, if you get in there with a spectroscope or something, you could probably find that the new paint doesn't perfectly match, even though you can't see the difference. So how matched does match mean? And if it's in an industry, it means whatever the standards of that industry are. If it's if it's an individual, and you say, you know, I want something done a certain way, how perfectly close to that certain way does it have to be? And the answer is that it depends. If something you want done is something involving fancy taste, you know, I want the walls painted in this room, and I want it painted, you know, just this certain subtle color, for some reason. And this certain subtle color is very important to me. And I make that very clear to you at the beginning. Don't paint it almost this color, paint it this color. Now, those high standards will apply. But if I just say paint it white, and then when you paint it white, I don't like the white that you chose, that's not going to work. But if I chose a particular shade of white and saying it's got to be this, that works. So fancy taste, if I make my fancy taste clear, the person has to do just what I wanted. When it's not fancy taste, it's just functional, and I want the thing to function. I want you to repair my car so it functions, repair my plumbing so it functions. If it's just functional, then that's all it has to do is to meet the functional utility. In this case, shingles matched, there is an industry sort of concept of what matching is. They either did or did not meet that standard. Now, do we have fancy taste here? Because if we have fancy taste, then the builder has to meet those standards, even though it's difficult. And so I think you may have fancy taste here because if you look at your house, you want the shingles on the roof and the shingles on the garage to match. And you'd say that was fancy taste, and the builder should have matched them perfectly, even though it cost a little bit more. So I think they should have matched them perfectly, but there's a debate here. The owner did not make it perfectly clear that I require a perfect match. And when you want fancy taste, you need to make it very clear to the other side that fancy taste is involved because their standard of performance is now much higher to meet your fancy taste. So you got to make that clear at the beginning. And was that made clear at the beginning when the contractor simply says the roof is to be matched to the house? Well, I don't know. Take your pick. So you may or may not have a breach because the matching may or may not be close enough. It may be close enough for industry standards, and it might not. And it clearly is not close enough for the owner's standards. So we may or may not have a breach because of that. Continuing with the problem, it then goes on to say that Carter finished 10 days late. Well, is that a breach? We're all dealing with breach now. First one is with the mismatched shingles a breach. Is finishing 10 days late a breach? Well, contract said time is of the essence. I didn't read you that part, it says that. But the rule is that even though you say time is of the essence, time is not treated as of the essence unless it's really true that time is of the essence. In other words, you just can't go around putting time is of the essence in all your contracts and expect that to be enforced. But if there's some reason why time really is of the essence, and I put that in my contract, then it is enforceable. Here, this person is building a garage next to somebody's house, and it's in the summertime in April and May. And they say time is of the essence, but there's nothing about the facts here that makes a 10-day late finish particularly important. It's a minor breach, and you pay a $1 or something for the minor breach, but it's not a material breach because time was not really of the essence. So that's what happens with the time is of the essence. It ends up being a minor breach. And finally, I won't put all the drawing on the boards, but the garage wasn't, he put an interior wall in the garage so that they have a little storage space at the end of the garage. But the place where the builder put the interior wall made the storage space too large, and the car wouldn't fit inside the garage. You couldn't close the door. And so that obviously is a breach, and you need to have the contractor move the wall back, and that, again, would probably be a minor breach because the cost of doing that wasn't expensive. And so, once again, without all the details of any of these problems, you see the structure. You see how you form contracts, you go through this major structure, and when you see these contracts problems, if you always organize your answer in that way, organize your answer so that you keep these blocks in mind, and it helps to separate it and helps to give you a much more organized answer. So that is our overview of the law of contracts. Please keep it in mind, use it, and that is the end of this lecture.